Paragraph 10 deals with various disclosures that are required either by law or in this contract. So I'm going to discuss each one. Paragraph A is a rate on gas disclosure. This is required by law to be in all leases and contracts and is just simply a statement that rate on gas is a naturally occurring gas. If the buyer is concerned about this, they can do the further testing, but the testing must be done within the inspection period in order for the buyer to back out if there shows appreciable rate on gas. The next one is permits disclosure. Remember, under an as-is contract, a seller must disclose everything that has a material effect on the value of the property. Open permits and undisclosed permits are required by the seller to be disclosed to the buyer. Then the buyer can decide whether they want to require seller to either close those out or take it property as is or terminate under the inspection period. Paragraph C is mold. And in Florida, with our hot, sticky environment, if you're worried about mold or if you have health issues, we have a mold addendum that allows you to do an inspection for that mold and then terminate if there are mold issues or require the seller to do some type of mitigation. Make sure you do that within the inspection period. If not, we would do an addendum to have that mold inspection its own inspection. Another disclosure under Florida law is flood disclosure and elevation. Elevation is the bottom of the first floor above the mean high water line. We do have an addendum that is attached to the contract called a flood disclosure. After our recent hurricanes and other flooding issues, it is very important for the buyer to know that if the property has flooded or not. It is required by the seller to disclose if the property has flooded or not. And of course, going back to the mold, if the property has flooded, there's a likelihood of mold. So be very careful with this. Paragraph E deals with energy brochure. That's for new construction. Paragraph F is lead-based paint. This is required. Anything built prior to 1978 may have lead-based paint. So therefore, there's a required disclosure by law if the property was built before 1978 to give a buyer an opportunity to do those inspections and testing if they want to. Paragraph G deals with homeowners associations and community associations. Most properties in Florida are either a condominium, which is a condominium association, or especially the new developments, they're in homeowners associations, and buyers want to know if there are rules, regulations, or fees associated with those. So the contract will have an addendum, either a condominium addendum or a homeowner's addendum, to reflect whether it's in an association or not. And it's very important that the buyer obtain these documents. The paragraph H deals with property tax disclosure. Remember, in Florida, real estate taxes are paid at the end of the year or in arrears. So during most of the year, except the end of the year when we actually know what the tax amount is, we base the tax prorations on last year's taxes. And then the contract calls for a reproration if either party wants to get it to the penny once the new bill is obtained. The title search will also discover whether the taxes have been paid or not. So we'll take care of that when we do a closing. Paragraph I deals with if it's a foreign seller. A foreign seller is required to pay up to 15% to the IRS when they sell property in this country. This is a result of the foreign sellers not paying their correct taxes in the past, and Congress came up with this FIRPTA, a Foreign Person Withholding Act, that requires a seller to withhold 15% of the purchase price. The exception to the rule is that if the property is under $300,000 and the buyer intends to reside in the property at least 50% of the time the property is occupied, then there is no foreign tax withholding. Last but not least, probably is the most important disclosure, which is a seller disclosure. This is required by law that a seller must disclose all material defects that they know about the property that has an effect on the value of the property. As a result of this required disclosure, the FAR Bar has prepared a seller disclosure, which is a 4 or 5 page questionnaire that helps the seller comply with this obligation. The seller doesn't have a choice of whether not to disclose something. They have to disclose something, and if they don't, there is ramifications in the fact that the buyer can come after the seller for either damages or rescission of the contract. And these issues will be found, and so please advise your sellers never to shirk this duty.